We have two, Member Brown-Burke and Member Morgan. All right. So at this point, I would like to welcome the students, staff, and teachers from the Salt Savannah Primary School in Clarendon. Welcome to the Parliament of Jamaica. You are seeing us in action at what's called the Joint Select Committee to discuss a particular bill, to go through all the parts of it, word by word, sentence by sentence, clause by clause, to agree on the bill. You're not seeing many persons in the Parliament today. You're not seeing many MPs in the Parliament today because this is a committee meeting and some of our members are online. If you look at the screens, you will see some of the members are online. It's a small committee of persons. In fact, it looks like about 12 persons make up this committee, and so we're here to discuss the bill. We welcome you to be in the gallery to watch the proceedings. Unfortunately, you won't be able to take part in it. You're only here to observe. So welcome again to the Parliament of Jamaica, to Gordon House. Thank you. So we'll move on to the confirmation of the minutes of the meeting held on Wednesday, April 5, 2023. Senator Brown, do you wish to speak? We're not hearing you, Senator Brown, if you can hear us. Still not hearing you, Senator Brown. Morning. All right, we have to move on with the confirmation of the minutes. Maybe the microphone for Member Brown will be fixed, and then we could take him at that time. So let us... Okay, let me welcome as well our two parliamentary interns who are online. Anastasia Barford and Aaron Hoylett. Welcome. All right, let's start with page 1 of the minutes.
Madam Chair, a very minor correction on page 1. There is a hyphen in my name. Campbell Rodriguez is hyphenated. We have reverted to taking out the hyphen, but it's hyphenated.
All right, so noted, member. We'll move to page 2.
Chair.
Yes, Member Hamilton.
Under subclause 58.4, at line 1, 2, 3, 4, 5, 6, line 7, it starts, she explained that it would only be notified of under. I think something needs to be removed there, or we need to clarify what exactly is being said. She explained that it would only be notified of under subclauses 58.3a, etc. So maybe we remove the off? Yeah? All right.
All right, thank you, member. We'll move on to page 3.
Madam Chair, the first sentence, I'm wondering if we could stop the sentence at the word employer, because the last part after that is saying the same thing as the first part. So to say Member Green sought the possible harm is the same as saying what was the matter being guarded against. I'm wondering if we can stop the sentence at employer. It's repetitive.
Should it say sought the possible
Excuse me?
harm, sought the possible harm to be done or something?
I can't hear you, Madam Chair.
Should it say sought the possible harm to be done or just leave it at
Possible harm. It can be left as
Yeah.
possible harm.
Okay.
But we just end the sentence at the employer.
Okay. Page 4. Page 5. On page 5, subclause 59.2. I'm sorry, just for my clarification. Do we say Attorney General's chamber or chambers? Chambers, all right. All right, let's move on to page 6. Page 7. Page 8. Page 9. Page 10.
Madam, page 10, first paragraph, the first sentence. Senator Brown sought clarification on whether the suspension would be done without a hearing on the mere fact that a person was charged, and Mrs. Gordon-Jones noted this was a separate issue to be treated with, which was suspension resultant on being charged. That part of the sentence, there's something wrong. It was fine up to Mrs. Gordon-Jones noted this was a separate issue to be treated with. But then after that, I'm not clear. There's something missing from that sentence.
Mrs. Gordon-Jones, we take a look at that.
What we could do is at the word with, we put a colon and remove the words which was. For me, that would be clearer, but I stand to be guided. So you put a colon at with and then remove which and was, and we should be okay. And Madam Chair, in paragraph 2, which begins the first sentence with Mrs. Gordon-Jones, that's fine. But in line 3, towards the right where it starts, he provided, we have to state who the he is, since in that paragraph there was no he mentioned before. So I think it is Senator Brown, I'm assuming. So you have to start the sentence with Senator Brown.
But let me go back to clause 60. Mrs. Gordon-Jones, do you agree with the slight rewording there? Does it still maintain the meaning?
Good morning, Chair, committee members, and colleagues. I think what Senator Rodriguez suggested would remedy the sentence.
All right, thank you. We'll move on to the final page, page 11. All right. So we'll ask for the confirmation of the minutes.
So moved, Madam Chair.
Moved by Member Rodriguez. Second?
Second, Chair.
Seconded by Member Gale. Are there any matters arising from the minutes?
Madam Chair, just the matters which were mentioned in the email that I don't see on the agenda, the pieces of legislation that were discussed in the minutes. It would be good if we could just even have copies printed, if you don't mind. I have no copies here. Love to see them, please.
This is from the opinion of the AG, Senator? Senator? Okay.
Yeah, the opinion.
All right, members of the actual cases were distributed in soft copy. You look in your email, but we don't have a hard copy version of it today because they were experiencing some problems with printing.
Okay, all right.
All right, so we'll move on to matters for discussion. This will be continuation of the clause-by-clause review.
Chair.
Sure. Go ahead, Mrs.
Sorry, in terms of, I'm not sure if the matter arising could be brought to matters for discussion, but subclause 5946 were to be considered by the Attorney General's chambers. I'm not sure if the chambers will be able to provide us with that response today.
There was a document in the email that was provided.
No, that's 59.
It was for 59-2.
46.
Okay. All right, so sorry. All right, two things. One, before we move on, I'm checking with our online members to ensure that they're hearing us and that they could speak if they need to. Just indicate in the chat if you're not. And item 2, I'm going to call on the Attorney General's chambers in terms of the research they have done, if they could begin in terms of their presentation. Mr. Foreman, unfortunately, we're not hearing you. So we're trying to get our technical persons to help us figure out what is going on. All right, can we do a test again? Mr. Foreman, you can try again.
Sir, hello?
Good, we're hearing you now. Please
Okay,
go
good.
ahead.
Good morning, Chair. Good morning, everyone. I was just seeking clarification on what we were being asked to do. The document that we sent this week was just a written version of a presentation that we had given at the last sitting. And it doesn't add anything to what we said on the last occasion.
What I'm hearing, Mr. Foreman, is that what we need is for clause 59.4. 4 to 6.
Well, we have not had any further consideration.
Go ahead, Member Hamilton.
You know, Chair, I think it is something that has to be considered, so maybe it can be provided at a later time. Well, it will need to be considered. So I think we should allow Mr. Foreman to review that particular section and revert soonest.
Mr. Foreman? Clause 59.
Sorry, good morning. Good morning, Chair and colleagues. Morning.
Good morning, SG.
Sorry to interrupt. I'm not sure what exactly are we what's the concern with 59.4? And I'm assuming it's 59.4 in the document that was circulated, because we have so many different drafts. I think this was circulated by Mr. Nash on 2:32 a.m. this morning, dated 15th of March. Is that the draft we're looking at? Because, you know, there have been so many drafts. I'm assuming that's the one. And I just wanted to know what's the concern. What are we being asked to look at in particular?
Madam Chair, if I remember well, so the one before us is dated March 2nd, May 2nd, sorry, and it deals with clause 59.2. What we're concerned about is clause 59, subclauses 4 to 6. And if you look in the minutes on page 9, second paragraph, last sentence in bold, the committee deferred subclauses 59, 4 to 6 for further consideration by the Attorney General's chambers. And if you review the paragraph in the minutes, it will outline clearly where our concerns were.
Chair, and through you to Senator, thank you very much for the clarification. We'll have to look at it because this is something we omitted to do. I apologize for that.
All right, thank you, SG. So we will await a response from the Attorney General's office for clauses 59, 4 to 6. So could we move on, Mrs. Gordon-Jones?
Chair, I think the other matter arising was in relation to 61. There was a discussion around 61A.
Not hearing you too well.
61A and B in terms of whether or not 61A was applicable in the circumstances. And the circumstances in a situation where whereas the suspension relates to a disqualifying offense, if the professional practice and conduct committee can cancel the suspension, notwithstanding the circumstances under B.
Any comments on this from members?
No, Madam Chair. It was deferred as well for consideration if we look at the last paragraph on page 10. So we were actually hoping to get feedback based on the discussion. I personally have nothing new to add. I was just waiting on comments. Because the last paragraph, it's also highlighted that this 61 was supposed to be deferred for us to get consideration and discuss today.
Chair, based on my recollection, the discussion ended prematurely, and so we needed to look back on the clauses to see whether or not 61A was applicable.
All right. Yes, I recall. That's in my notes as well. There were many questions. I have one here that came from the SG as well. and so on. So we'll begin there in terms of our interrogation.
You want me to read? 61. Where a suspension relates to a registered teacher, licensed teacher, or instructor who has been charged with a disqualifying offense, the suspension remains in force until the earlier of the following occurs. A, the professional practice and the conduct committee cancels the suspension, or B, the charge that forms the grounds for the suspension is dealt with in any of the following ways. 1, the charge is withdrawn or the prosecution for the offense charge is discontinued. 2, the person dies without the charge having been determined. 3, the charge is dismissed by a court. 4, the person is discharged by a court following committal proceedings. 5, the person is acquitted of the offense by a court. Or 6, the registration, license, or grant of an authorization to teach of the person is revoked because the person was found guilty of a disqualifying offense by a court.
And if I remember well, Mrs. Gordon-Jones, the big question here was whether or not the professional practice and the conduct committee could cancel a suspension.
So, Chair, my understanding is that based on the fact that the teacher will be charged with a disqualifying offense, by virtue of being charged with a disqualifying offense, then the provision provides that the council may, the PBCJ may suspend that person's license or registration or authorization to teach. And then the suspension, if it is suspended, then it remains in force until one of the items at B occurs.
So that means, Chair, that we can only await what is contained in B before any action takes place. And so it does not give the prerogative of the PPC to cancel the suspension in the first instance. We'd have to await B 1 to 6 for any action to take place. So that nullifies the PPC to take an action. That's my understanding.
And I agree with that, Chair. I mean, there is no way that the PBCJ would be able to cancel suspension on its own without one of these conditions being present. So having A really makes no sense.
All right, I put it to the members.
I share that view as well.
All right, thank you, Member Brown.
Same, the view of Senator that MP Hamilton just gave. A is necessary.
All right, so confirmed. We will move on to clause 61.
Chair?
Yes?
Before you move to
Or
clause 61,
61, yes.
we would like to draw the committee's attention back to clause 60, subclause 5, or 4 and 5, we are proposing that based on the reading of 5, which is similar to 4, that 5, which was previously inserted, which was a clause that was inserted after the actual draft. We are proposing that it be removed because it's a similar reading to subclause 4.
And that would be the entire clause, A, including A, B, and C?
Yes, Chair.
Okay.
Just quick reading. How would you treat with in 5B that speaks to reimbursed as prescribed for the period of suspension?
Except that, member, that the matter of reimbursement would be treated with under regulations in terms of the persons who are treated with education regulations. So the whole matter of reimbursement, the discussion was that since it is a matter for the employer, it is supposed to be taken from the bill. That's the discussion that was had.
So there would be a reference somewhere to speak to regulations addressing that aspect.
Why I raise the concern, Chair, is the mere fact that upon a reinstatement allows for certain other actions to take place. So the person would now be reinstated and have the opportunity to continue to operate. But it also assumes that there would have been a period to which they would have to be reimbursed. And there ought to be in this area, if you are taking out 5 in its entirety, and B that speaks to reimbursement, I would want to suggest, like Member Hamilton has indicated, that there be some reference that ties it or connects it to the regulation.
Minister, I share the views of members Gale and Hamilton.
Madam Chair, may I ask Mrs. Gordon-Jones or Mrs. Douglas-Sherland a question? Could 5 be kept and just written to include B? Is that possible? So it would read, where a registered teacher, licensed teacher, or an instructor has been discharged or acquitted of a disqualifying offense for which the registration, license, or authorization to teach of such person was suspended, that person shall be reimbursed as prescribed for the period of suspension. And we just have that section there. Is that possible?
Go ahead, Member Hamilton.
Or
and then
maybe we could remove 4 and keep 5 as a substantive clause. Yeah, because under 5, it speaks to discharge or acquitted of a disqualifying offense. It pretty much
But you'd have
subsumes.
you'd have to carry the last sentence from 4 over, because I think that's important, where it says, to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach. I think it's important we carry that piece.
And that's fine. But I think we can just condense.
Yeah.
I remember that the suspension can happen in 2 cases under the bill. There's a suspension where you will not be reimbursed, and there's a suspension that you will be reimbursed. So remember, once a disciplinary inquiry is conducted, remember the PBCJ can suspend the person. In that case, the person is not entitled to reimbursement, because that would be the action flowing from that inquiry. But in this case of a person being charged with a disqualifying offense, if the person is acquitted or so, then the person would be required to be reimbursed. So you cannot merge the two.
So, yes, there are two different types of suspension. The suspension that you spoke about earlier would have been the disciplinary charge. And the second one is the suspension to carry out the investigation. And there's a suggestion now that if the person is acquitted and reinstated, then we speak about the reimbursement. The 4 could be contained, and we attach 5 to speak to, again, the activity of reinstatement and the supporting action in relation to reimbursement. So we may even want to consider to expand 4 and break it out.
Madam Chair.
Madam Member Rodriguez, SG has had her hand up for a little while now, so let me recognize her. Please go ahead, SG.
Okay, thank you, Chair. So the first thing is the terminology reimbursement is not what we usually use. And in fact, I think we need to distinguish a few things. So if someone has been subject of disciplinary sanction and the penalty is a suspension, then clearly you cannot, and your salary was withheld for the period of the suspension, clearly you would not be able to recover those funds. What I think you are looking at is when someone is exculpated, whether after the result of disciplinary proceedings or if they were charged with an offense and they have been suspended. Once there is exculpation, that person must be able to recover all the funds that were not given to them. It doesn't matter whether they were reinstated or not. So I would prefer we use other language. So first, the language of reimbursement is not a reimbursement. And I'm going to read from the public service regulations because I think this is the kind of language that you would want, where it says where disciplinary proceedings against an officer under interdiction from duty results in his exculpation, he shall be entitled to the full amount of the salary which he would have received had he not been interdicted. That is a language that you need. So it's not conditional on whether the person is reinstated or not. The condition is that the person was suspended, did not receive their salary. The person has now been exculpated. They are to recover the full amount of their salary. I would commend that we use that kind of language and insert it in 64 if the committee agrees to delete 65. Thank you. And for the draft, you can find it in Regulation 32.4 of the Public Service Regulations.
All right, thank you, SG. Member Rodriguez.
She has solved the problem. So I'm fine, thanks.
All right, please proceed, Ms. Gordon-Jones.
Clause 61. The registration or license of a teacher or the authorization to teach of an instructor may be revoked either for a specified period not exceeding 2 years or until the fulfillment of a specified condition. The revocation of the registration, license, or authorization to teach by the council in relation to a disqualifying offense remains in effect during an appeal to the tribunal. 3, where the professional practice and the conduct committee decides to revoke the registration, a license, or authorization to teach under Section 58, the council shall, on receipt of the decision, A, instruct the registrar to remove the name of that person from the relevant register or roll, and B, publish the decision of the publish the decision of the professional practice and the conduct committee in the Gazette and a daily newspaper circulated in Jamaica. 4, a person...
Sorry, Madam Chair, can I ask a question in 3? And I might be going back, but I just want you to bear with me a little bit. If in 61.3 we say the council shall, why did we change, please remind me, 3B, that you're not publishing the decision of the council versus the decision of the committee. What was the thought behind it? I just stand to be reminded. Because I don't think the PBCJ on its own makes decision. The same way we say that they could not reinstate a teacher. It's the same way it's a council that needs to do it. So it should publish the decision of the council. It's as though we're giving the PBCJ this power of an entity all unto itself. So I think 61.3b should remain as was. Publish the decision of the council, not of the committee. Unless there's something I missed, which is very possible. Because even though a committee makes a decision, so for example, this joint select committee of the parliament will make decisions, but it is not, can't be activated until the parliament does so. I would think it's the same thing with the committee and the council. Madam Chair, may I ask Ms. Gordon if she has any thoughts on that recommendation I'm making? Gordon, Winsome Gordon.
Dr. Gordon.
Yes.
Yeah.
Thank you very much. Good morning, everyone. Morning, Minister. You're right. The PBCJ advises the council, and the council sends out the decisions. So you're right. We accept that. Thank you.
So, committee, I put it to you. Clause 61B, that we publish the decision of the council in the Gazette and a daily newspaper circulated in Jamaica. So moved. Members?
Chair,
it appears that there's support for that position in previous meetings, and I stand by it in this one. That is to say, it is the council's action that has to be reported.
All right.
Yes, as long as there's uniformity.
Yes.
I'm good.
All right. So, Ms. Gordon-Jones,
I'm fine.
Please move on.
(61.4) A person whose license is revoked shall, within 7 days of the date of the revocation, surrender the license and every copy thereof to the council. A person who...
Sorry, question. What's every copy? Is it that when you get your license, you get more than one copies? Or do you mean a photocopy that the person may have? What's the thought process behind surrender the license and every copy thereof?
A clarification there to you, Minister.
Electronic versions of it as well?
Yeah, but...
because I would think it's just one valid document. One.
Go ahead, Member Brown.
Yeah, what is the nature of the license that required to be surrendered, as against it's simply a decision has been taken that license is no longer valid? What is the need for physical surrender of it? And
Agreed.
What will it look like to require that?
Agreed.
In other words, Member Brown, if the license is revoked, it's revoked. It's no longer operative.
That's my view. In other words, if my driver's license is suspended, do I take it to the tax office and say, or to the Island Traffic Authority, or just suspended by the mere fact that a decision was taken elsewhere? And if I'm caught using it, then that's an offense.
The license is, sorry, through your chair, my understanding in relation to driver's license, Member Brown, that the license is to be brought in.
Sorry, Member Brown, Member Green, you're saying the driver's license to be brought in?
Yeah, that is my understanding of how the process operates. The license is to be handed over. Okay. I can't tell you if it happens in the main. I know that there are occasions that people who are in court on their license is suspended, or that they hand over the license on spot. But they are to bring in the license to the Island Traffic Authority. That is my understanding of the process. I can double check just to be certain.
Yeah, and what will be the form of the license?
Member Brown, SG had her hand up. Go ahead, SG.
Sorry, I just...
Thanks. I just two things. I was wondering if I can also check the Road Traffic Act. I know that if the license is disqualified, it definitely is to be brought in. I'm not sure about suspended.
Okay.
But usually this is something that we do with, let's say, I'm just picking something, a casino gaming license. So usually when you have licenses for businesses that are usually displayed, so, you have a lot of business that must be licensed, and you have the display of that original license. If that license has been revoked, then they usually want that original license to be returned. This is not quite the same. And so I'm not sure why this is needed. I'm thinking of other professional bodies. So I'm an attorney at law. If I was given, and I get a certain type of certification, I don't know that I need to return it because I've been struck off the roll. So I'm not sure that it fits here and it's even necessary, because what's important is that the revocation is published and persons would know.
And if they need to check, then the source of truth would be the council.
Right, and I'm sure the council may even have a website where all this information would be available to the public about persons who perhaps they'll do it the way a lot of other professions do it, which is you can look to see who is a registered teacher.
Dr. Gordon.
Thank you, Chair. May I humbly submit that the teacher ought to return the physical license, because the teacher will have an electronic license with its information, so on and so forth, and that card should be returned to the council.
Madam Chair,
may I ask a question? Member Rodriguez, and then Member Brown, then Member Green.
I don't think the physical license need to be returned, only because, one, how do you enforce that? And how many things do we do constantly that we can't enforce? The onus is on employers to always check the roll to ensure that the teacher they're seeking to employ is licensed. So even if a teacher goes and pretends by showing the card, it shouldn't be an issue, because the onus is on the employer to always check before they hire a teacher. So I don't think we can enforce returning the license unless we're going to put a penalty there. And do we want to penalize that? I'm not sure. We don't want to. So I think it should be, you don't have to turn in the physical, but you're struck from the roll, and the roll should be available for viewing on the website of the Teaching Council.
The public communication in Jamaica is not as good as sometimes we think. And there are places in Jamaica that where we have schools and the principals don't have access to the information. So the safest way is to take back that card. It's an electronic card, to take the card back, because a teacher could use a card in Penline Castle or in Old Pira and the principal has no electronic connection at the time to check the card, it's possible, because that is, we assume that Jamaica is fully covered electronically, but this is not entirely true.
Madam Chair, a phone call to the regional office by the principal will solve that problem. Any principal that does not have internet at school should be able to pick up their phone and call the regional office. The onus has to be on an employer, let me not say principal, to the board or whomever to check the roll. Because even if the person doesn't have a physical license to show, they could simply say, if we're going down that route of dishonesty, they could simply say, oh, it got wet when I accidentally washed my clothes with it in the pocket. So it has to be, the onus is on the employer to check. And everywhere in Jamaica has phone connectivity.
All right, so I think it was Member Brown next, and then Member Green.
My point has been made by several of the speakers prior, which is that there's no need to surrender a physical document, and we should have it in there. Thank you.
All right, thank you, Member Green.
Yeah, sorry, Chair. I just wanted to be clear, and I thank the SG. I think he's right in relation to the disqualification. But in relation to my position, I see no need to make it as a requirement for somebody to have to bring in the physical copy of their license. I join with Member Brown, I join with the SG. I believe it is an offense if one were to go and teach with their license having been suspended. There are other safeguards in the law. So I don't think having a requirement in there for them to bring in the license is practical.
All right, I put that to the committee members. All right, so confirmed. We will move on.
So Madam Chair would then have to take out 5 as well. So 4 and 5 would have to be removed.
Yep. Yeah, we don't want to create an offense. Yeah, we don't want to create an offense with that. No, honestly. So I put it to the members.
A decision that is not going to work for the country.
5 should be omitted as well.
Agree.
Dr. Gordon, you want to say why it wouldn't work?
Minister, communication, even now, communication is not that good. I see no problem in the teacher returning that electronic card to the council. The teacher will not have that card if the teacher is suspended or the license revoked. I see no problem with that. When the teacher is left with that electronic card, goes to schools in Washfoot Gully, for example, and maybe none of us know where, no one here beside myself maybe, know where Washfoot Gully School is, but it is there. And when the teacher goes to Washfoot Gully and shows his card, the verification is going to take a long time, or maybe the poor principal is so glad for a teacher that he might not even bother, or she might not even bother to go and verify. So let us not create a problem where there doesn't have to be a problem.
Yeah, but why
we just take our license. I don't see anything wrong. What is radically wrong with getting the physical copy? What is radically wrong with that?
Someone paying a bus fare, a teacher having to pay a bus fare to go turn in a card that they can't use if the rules of the regulations of the bill is followed. A principal, I take your point, they may not have an internet access, but they do have a telephone. They can call the regional office and just confirm. That does not take a long time. So let us say the operator at the regional office doesn't answer the phone on the first try. You keep trying every 15 minutes. So within an hour, you will have a response.
That's not the way the bus fare against the care of our children.
Could I say, Dr. Gordon, the hiring of a teacher has to go through different rounds, and there has to be checks along the way.
Chair, I'm very concerned that it is being said that upon the hiring of a teacher, you may not necessarily go through a verification process. Regardless of whether or not that person has the license physically, you still have to go and through the process. So I don't take that point as the reason for us to keep the clause or to remove the clause. Every employer has to verify whether or not a teacher is able to teach.
Member Green?
I'm not.
I'm sorry, hold a second. One second, Member Green. Member Green, 1 second. Let Dr. Gordon finish that point.
Yeah. It takes a long time. The teacher could commit a whole lot of damage against our children for no good reason. We have no good reason. The teacher just brings in the card.
Hold on. What do you mean by the teacher can cause damage?
To be honest, I'm completely bewildered by what Dr. Gordon is saying. Dr. Gordon is suggesting that once a teacher goes to a school and presents a card to say that they are registered as a teacher, that there will be no further checks that will be done by the school. That could never be what we are countenancing. There must be, even to verify that the card presented is valid. That must happen.
Thank you. Yes.
I mean, that is the first step, because suppose somebody, as people are known to do, creates a fraudulent card representing themselves to be a teacher, which we've made an offense in the act. It suggests that once you go into a school and you say, I am applying to teach at this primary school, and the person says, okay, submit your documentation, including a copy of your registration to teach, right, or your teacher's license, then there must be a process before the person is hired to reach out to the teaching council to say, is this individual duly licensed? Now, if we were to suggest that anything apart from that process would be countenanced by the council, would be allowed, would be acceptable, is absolutely absurd. The schools must check before they employ the teachers. And we are saying that in that checking process, they will be able to ascertain whether the license has been suspended. I think it is reasonable to put the burden on the schools because it is a part of their duty of care.
But they have to do that. They have to do that now, anyways. In hiring, Member Green, they have to do some kind of verification right now.
Absolutely.
In hiring, they have to check to see that they did graduate from the college that they're purporting to have graduated from, and so on.
But additionally, Chair, I also want to clarify, because Dr. Gordon also mentioned that we could be putting the children at risk. So is it that persons are allowed to start teaching before this process is completed? Because if that's the case, then we also have a difficulty there.
It should not be happening.
It should not be happening.
Should not.
Many things should not happen, but they happen.
No, put a VP in the class before you do that.
We have teachers who have committed, not many of them, but they commit certain crimes, and they go to other schools far, far away and commit the same thing.
But that's why we're implementing this legislation now, though, Dr. Gordon. That's why
this is a new system. And in addition, Ms. Gordon, I'm sorry to be cutting you, but I think I need to, because you're probably thinking of the old system. The purpose, if we listen to what the chairman of this committee has said more than once, we are lifting the standard of the teaching profession. And we have discussed this issue of catching persons who have committed crimes before, because a lot of persons don't know that currently you don't need a police record. But are you saying that having the physical card would stop you from committing an offense before you have to renew? It won't.
It would be a deterrent.
No, it won't.
Because you would not have that card to give a principal in a book.
No, it won't. And it's a new system. And if we're moving into the new system with the old way of thinking, we are already in trouble. We have to let the system work. And in addition, Madam Chair, to create a new offense for a teacher in rural Westmoreland, for example, to take a day off of work, where that principal then has to take a day off from work to come into Kingston, is saying a lot. We can't create, Madam Ms. Gordon. Okay, the teacher is not at work, but we're creating a whole new offense. Do we want to create a whole new offense with a penalty?
No,
we do. I am not comfortable as a parliamentarian doing that.
Okay,
the digital space is not as efficient as we would want to think in Jamaica.
Let me bring in Member Miller.
It is not as efficient.
Member Miller and then Member Green.
Thank you, Madam Chair. I would agree with Member Green, Member Hamilton, with what was stated earlier. It would be unjust for this committee and also for the Teachers' Council not to verify the material that is presented. We're living in an era, Madam Chair, where persons can just buy an equipment and create a card. You know, it's very important and it's very paramount that we verify the information. I don't believe that having that card is a deterrent from persons to do things that are unjust. And we have a duty of care to ensure that the persons that are within our care, which are the students, our main clients, are well protected. So I would be of the view, as my colleague articulated perfectly earlier, that due process must be done and verification must be done where this is concerned.
Why do we take driver's license? We should leave the driver with his driver's license and his conscience. Why do we bother to take the driver's license? We don't take it.
Yes, Dr. Gordon, but persons can create any driver's license. Persons can use a machine and create a driver's license. A driver's license doesn't stop a driver from committing a road traffic violation out there. It doesn't prevent the person. Even the driver's license is not looking at the driver's license is not a surety that a person has a driver's license. But we have to verify the information to ensure that the driver's license is authentic.
All right, thank you. Member Gale? All right.
I just simply want to say that the legislation, the scope of the legislation would have already strengthened the objectives in terms of employing a teacher by the accommodations and the provisions of licensing and registration and the need for that institution to treat with the verification, irregardless of where they are. And Dr. Gordon, I really like to know the geographical location as to Washfoot Gully. But, you know, the revocation of the license is already a critical provision and being purported in the legislation. I have a great difficulty in agreeing if the teacher whose license would have been revoked and they didn't turn in the license or surrender the license and the many myriad of copies that they are going to be exposed to a penal fine of $500,000.
Not happening.
So one, just take the first one out in terms of the commitment that is being asked to surrender the license, because it's already revoked. And so we don't have to continue this deliberation on the matter. I can understand the emotions around it, but I think the legislation is already strong enough in protecting against anyone who may seek to operate without a license.
Thank you, Member Gale. Member Green.
Sorry, I think maybe I should not belabor the point. You know, I appreciate what Dr. Gordon is trying to do, which is to put in another layer of protection by mandating that those who are no longer a part of the profession will have to turn in their license, and as such reducing the risk for fraud or for them to end up in the classroom. I appreciate the thinking behind it. The part that I have a challenge with is that, you know, sometimes we do these things instead of fixing the system to ensure that it would be extraordinarily difficult for somebody to end up in a classroom without the proper checks and balances. You know, some of the comments that this is what happens, that unfortunately a man might go to a far off school and may end up in the classroom. I genuinely believe that that is the area that we need to fix, and that we need to ensure that it's based on the part that we have control over, which the reality, even though people are mandated to take in their driver's license, if the license has been disqualified, the reality is a number of them still do not. And as such, part of the journey has been, how do you fix the system by using the technology to ensure that you can easily, quickly identify when somebody has been disqualified from driving. So if you come across them driving, you could quickly recognize that they've committed a criminal offense and as such treat with them. We need to fix the back end. We need to work to ensure that no teacher is going into the classroom without proper verification. If we fix the back end, it reduces the need for this additional burden for somebody to bring in their license. That is my view of it.
All right, I think we have ventilated this enough, and we are of the agreement that 61.5 should be struck out. 61.5 should be eliminated, struck out. Oh, 4 and 5, sorry. 4 and 5 should be struck out. Thank you. We'll move on to 62.
Chair, just before we move on to 62, I thought we were going to take questions after, so I had two issues to raise myself in relation to 61.1 and 61.3. In terms of 61.3, that's an easier one. Right, you mentioned something just now, Member Rodriguez, saying that it should be council, but that was not my indication. My indication is that revocation also takes place under Clause 59, and so the clause should mention both Section 58 or 59. Fifty-nine 59.2, that same clause that the Attorney General's chambers provided their opinion on, it speaks to revocation as well. And so the proposal is that it should also be referenced here at 61.3, where if the revocation takes place under that clause, then these actions are also to be taken for consistency.
Madam Chair, I agree that we need to adjust that, but I'm happy Mrs. Gordon-Jones has referred us back to that, because I have a question, if I may, Madam, on that same 3. As written now, based on the recommendation, it seems as though it's automatic that once the PPCC makes a decision, the council accepts it. Is that the case?
Yeah, I mean, why would you want the council to relitigate?
No, I'm not asking. I'm just wanting to know if we're firm on that. Yes. We're sure that once the PPCC makes a decision, the council accepts it.
Right, because we've set up this council to deliberate on all the facts surrounding the case and make a decision. Now, if there's an appeal, right? Isn't there an appeal process?
Right. No, I'm agreeing that it should stay as such, madam. I'm just saying, if that is the case, then as written, you would strike out the council as, because I know you referred to my saying council, but in this instance, it would be correct based on that decision.
And that means then that B should also remain then?
No, it's different.
It's not the same.
It's two completely different things. So 3 should remain as corrected. Where the PPCC decides to revoke the registration and license to teach, the council shall. So it's the council doing the action. And once we have confirmed that the council takes the decision of the committee, which we just confirmed, and I agree with that, then it's the council who does it. But it doesn't change what happens in 3B.
To you, Chair. Am I to understand that just now we're saying the council is a rubber stamp for the PPCC?
It feels like we're going backwards. It feels like we're going backwards.
Sorry?
It feels like we're going backwards with that question, because the whole
No. The issue just came up a while ago.
No, member. No, all right, go ahead.
Sorry?
Let me hear what you have to say, member.
It just came up a while ago, and I'm seeking clarification. Am I not allowed so to do?
Member Brown, the whole reason of setting up the PPCC, Professional Practice and Conduct Committee, is to have a body that will interrogate the facts of the case and come to a decision. The council shall accept the decision. There's an appeals process that we have described in this act.
So you're confirming that the council cannot say, well, maybe you came to your decision improperly or anything like that, or your decision is unlawful, and so we ask you to look back at it or so. In other words, the council has no say, it's just a rubber stamp. And that's the concern I'm raising, I'm seeking to clarify.
When you call it a rubber stamp, you're being pejorative and mischievous, honestly. You have to describe a process, which we have done. You have to set up an arm of the entity to interrogate. The decision has to be accepted. We have gone through describing an appeals process. For that to work through in the event there is,
But Chair, I mean, on what basis would the council refuse to accept the decision of the PPCC unless the council itself goes through that process? Because, I mean, the PPCC would have interrogated and come to a decision. How can the council, who would not have had that opportunity, make a different or come to a different conclusion?
Here, when we decided as a committee to establish the committee, the objective was to isolate the roles and functions and make it distinct. Now, the committee would conduct its work, and there are rules governing how the committee would conduct its work. and report back to the council every decision, providing reasons, and the reasons are outlined and established in the legislation. Now, having done that, I don't believe we could contend that the council is a mere rubber stamp. Because if the council, in its view, believes that the reasons submitted to it are not confined to the reasons expressively stated in the legislation, then the council can make a decision. I never thought it would be that at this stage of the deliberations we would be contending that the council as established would be viewed as a mere rubber stamp.
And that's why, Madam Chair, the use of the words decision versus recommendation. It's not a recommendation from the committee, it's a decision, because we have to be careful of the words we use because they have meaning. To say rubber stamp is putting a negative spin on what actually is a systemic process that has been thought through. I mean, we have deliberated it, and also the drafters, I'm sure, have done so as well. So I think we need to be careful with the words we use. It's not rubber stamping. It's the entity of the council that makes this decision, and that's what the committee is.
But Chair, additionally, if someone is aggrieved, for example, the accused person, by the decision, then there is a process that that person now can undertake.
I agree with you, members, and I am asking Member Brown to withdraw that comment. It belittles the work, the many, many man-hours that have gone into deliberating on the side. It just belittles the work of this committee.
I second that motion, Madam Chair.
Minister, we shouldn't waste our time asking me to withdraw my considered thoughts. They may disagree with yours and disagree with other members of the committee, but I strongly hold my view, and that in such a situation, it amounts to a rubber stamp if the council has no possibility of commenting on the decision, and they have to just accept it. So I stand firm by my decision, and I'm sorry, I can't withdraw an opinion which I hold sincerely and passionately. May the courts decide it when it comes up. At that point, maybe somebody will say, I was visionary.
My good friend, Senator Member Brown, with all due respect, I know Madam Chair articulated earlier that would have some children in the gallery that are watching the proceedings.
They're not here anymore.
Okay, and persons that are viewing online, as member stated, that the choice of words is unbecoming, and we should try and endeavor best to ensure that we do not use those words to really belittle the committee, because we have done a lot of work in the committee. You know, Madam Chair has steered the committee, and we have done a lot of work. So to use those choice of words, it's unfortunate. And I'll just, if you have not seen it fit to withdraw those statements, but I'm saying, as we move on, I would wish that you withdraw those statements, as Madam Chair stated. But as we move on, try the choice of words that we use. We have to be very careful where that is concerned.
I've heard choice of words in Portland. And is rubber stamping unparliamentary?
Nobody mentioned unparliamentary, right? And you know quite clearly as to what you're doing. And you're cognizant of that.
Very much so. I totally agree with you, Member Miller. We are gathered here as members to do serious work, serious deliberation. We have many technical persons here with us who take their jobs seriously. And if after so many weeks of deliberating, so many months, we get to this point and the council is being categorized in that way, then we have to think that there is something else at play here.
Minister, that's what you should withdraw. I have no improper motive. I'm simply saying that if a matter goes to the council, I'm not categorizing the council as a rubber stamp. I'm simply saying, are we saying that every decision that comes to the council should be mum on it and therefore act as a rubber stamp?
Madam Chair?
It ought not to be. And that's my considered views, and I put it out here. And the call for me to withdraw the word rubber stamp is not going to be met with any favor.
Member Rodriguez.
Madam Chair, I think it is important at this point, if yourself or Dr. Gordon or someone could just, for the public, because one of the things we have to be mindful of is that there are people watching on television and on YouTube, the proceedings, who may not have been listening to previous deliberations. And when they hear an emotive word such as rubber stamping, they may not understand the systems that have been put in place and why this decision was taken. And I think it is important for teachers who may be hearing this, for the media houses that may be carrying this, to understand why it is not rubber stamping. So, Madam Chair, if you would so help the situation by just outlining the process so that persons can understand the intention behind this, that it's not rubber stamping.
Mrs. Gordon Jones.
Chair, I am trying to understand why it would be the council's decision as against the Professional Practice and Conduct Committee. And as we were discussing here, myself and Mrs. Sherland, there are two members of the council, the board, on that PPCC, so the contribution would also come from those persons. So I'm not sure. And also, we are to be reminded of the clause 15.8, which says that it's a decision that is made by the PPCC, unless it is a recommendation, because I'm here, Dr. Gordon seem to have a separate view, which, through you, Chair, if you would allow her to speak on that afterwards, but we would need to know if it's a decision that the PPCC will make or a recommendation.
Madam Chair, sorry, before Dr. Gordon speaks, I think it's important. We took a decision that the council makes a decision, and the council, we're not changing that, and that's not what we're discussing. We're discussing whether or not what comes from the PPCC is a decision versus a recommendation. And Madam Chair, when this was originally discussed, we agreed as a committee it's a decision. And the reason it's a decision and not a recommendation is you could then find yourself in a situation where one issue is deliberated twice, including some of the same persons, because the committee is made up of members, it includes members from the council. And the council has a lot of work to do. And the committee, if my memory serves me right, is there to aid in lessening the work that the committee itself the council itself has to do directly. And as such, the configuration of the committee is going to be as such where their decisions and their deliberations can be trusted, and the processes they use are as such that the council would have been wanting to use the same process. So it leaves no room for there to be any new rehashing of the issues in the council, because of the fact that the committee and its processes would have been of such standard that there's no need to do so. And that's the rationale behind it. However, the council is the body recognized by this piece of legislation, and as such, it has to read that the decisions are those of the council. So I don't think we need to, Madam Chair, go back to the point of even giving any more light to this discussion that it's a rubber stamping. It cannot be a rubber stamping if you empower this entity to do work using processes, systems, and personnel that are of the same caliber as the council. So I think we can even move on, Madam Chair, because...
And on which two of your members?
Yes, and two of the members sit on it. It's not a completely different entity. And I don't think we should further discuss this discussion, Madam Chair, because we have spent a lot of time on it. And we, as members of this committee, stand by the decision that we made at that time, unless something new comes to light. That's for me personally. And I don't see anything new coming to light.
Yeah, I agree with you. I mean, in the labor relations world, once a tribunal makes a decision, the employers are bound to accept. And Member Brown knows that quite well. And again, I firmly believe that he's belittling the work of this committee. And if that is what he's out to do at this moment, then maybe he should make a decision about whether or not he continues to sit on this committee. It's just belittling the work by talking about it as a rubber stamp.
Yeah.
Minister, it's not your call as to whether I continue to sit on the committee. But I was chosen in the Senate to be on this committee. It's not your call. I stand by my views, and it's sufficient for me to say I disagree with you all on this point, because if two of whatever number of people sit on a committee and the others are bound to silence, that sounds like a rubber stamp to me. But thank you all for prolonging the controversy on this issue.
All right, let's move on.
Madam Chair, there's an inconsistency. We have to be very clear. This is basic English. Where the council decides to revoke the registration, and we can continue on that, and we come down to 3B.
Where are you reading, Dr. Gordon? What clause?
61, 3B.
61.
It says the same thing.
61, 3B. Yeah.
Then the concern, Minister, is that if it's the council that is going to publish in the Gazette, then it has to be the council that makes the decision. That's all I'm saying.
Dr. Gordon, no, Dr. Gordon, no, Dr. Gordon.
But that's what the statement says.
No.
You're not reading it correctly.
No.
You're reading it with what you want it to be.
Go ahead.
Madam Chair,
no,
let us go back to it, and I will break it down as my English teacher used to. If you empower a body to act, a committee, to act on your behalf, and the rule says the decision of that committee becomes the decision of the council, right? It means that whatever decision the committee has made, the council accepts it. And it becomes the decision of the council.
And the council
so
cannot
therefore,
distance itself from that
and the council
decision.
cannot separate itself from that. However, legally, it's the council that is the governing body. So it has to be the council who publishes the decision in the Gazette. Because in this instance, the council and the committee are almost one entity, from the standpoint that the decision of the committee is the decision of the council. So there's no dissonance here at all. We cannot allow because we want something to change. And it's fine.
I think we have to,
Madam Chair,
we have to look at...
Madam Chair, I wish to make a proposition. Perhaps because in 61.3, we say the council decides to revoke the registration and so on and so forth.
No. We've crossed out council long ago.
Sorry,
it's a professional practice.
Sorry, Chair. The PPCC decides to revoke. Then when we come down to B, perhaps we should just take out the words of the council and say publish the decision in the Gazette. So that...
Member Green? Oh, sorry. Huh? Oh, committee agrees. Okay, we can take that out. Okay. All right, we'll carry on.
Chair, so in terms of the insertion of R59, I'm not sure if it was put to the committee. Inserting R59 on the subclause 3 of 61.
61.3, 58, or 59.2, right? On the clause 61.3, where it currently says to teach under section 58, we're going to include there or 59.2. All right, so moved by
Chair,
committee.
I don't think would indicate the subclause. It's just 59. I'll be guided by the.
All right, or 59. Okay, 58 or 59. So moved.
Yes, Chair. The other issue that I had was in relation to 61.1. It says the registration or license of a teacher or the authorization to teach of an instructor may be revoked either for a specified period not exceeding 2 years. So my issue is the not exceeding 2 years. Because I'm thinking of a situation where a person's license is revoked as a result of being convicted of a disqualifying offense, and that person has a sentence of more than 2 years, right?
I had a question. Take out the not exceeding 2 years. Because the not exceeding 2 years, and if the conviction was more than 2 years, I wanted to ask if, or until the fulfillment of a specified condition, what does that mean? Because I saw where there could have been the possibility where it exceeded 2 years for the disqualifying offense.
Can't we just take out the not exceeding 2 years?
And just leave it open?
And just leave it as the registration or license of a teacher or the authorization to teach of an instructor may be revoked either for a specified time or until the fulfillment of a specified condition. No? Because the 2 years there is sort of binding us to something that may not be real.
The not exceeding 2 years specifies a limit.
Right.
And there may be circumstances where it would require
more than 2 years.
More than 2 years.
So just take it out. Is there a legal reason, a drafting reason we can't just take out the not exceeding 2 years?
Question. Isn't a revocation supposed to be final? Can you come back from a revocation? This is not a suspension, no, you know. You can come back. So if somebody commits a criminal offense and is convicted and the person's license is revoked, that person can come back into the classroom? I am very concerned.
You turn to 8.
May be revoked.
No, if you turn to 8, which is on page 15 of this document, I'm not even sure 8 what, but it's on page 15 of this review document, the one we got this morning. So I think that's 64. Oh, first schedule. In the first schedule, number 8. There's an entire paragraph there. The minister may revoke the appointment of any member of the board if the member becomes of an unsound mind, becomes bankrupt, is convicted and sentenced to a term of imprisonment, death.
Oh, that's different.
Oh. That's for the board.
This is dealing with the complaint.
Yes.
And the suspension or revocation.
Right. So revocation to me is a final act, just as how the minister can revoke the membership. When a teacher's license has been revoked, they shouldn't be able to come back from that.
Sorry, it's in 59, which is on page 7. Sorry, I was looking at the wrong thing. So remember, it says there that when you are, for example, charged with a disqualifying offense, it's not automatically revocation, it's suspension. 59, it's a suspension for a disqualifying offense.
Under 59.2, it speaks to know when the person has been convicted that the revocation can take place. So that's the final act that I'm talking about. So you shouldn't be able to come back from a revocation. There should be no limit about 2 years or anything. If it's revoked, it's revoked.
You're correct. I agree. Is it then that in 61 we're talking about both a suspension and a revocation?
Which is it that we are trying to establish?
Madam Chair, may I make a suggestion that the team just take some time to re-look at 61 within the context of our discussion where a revocation is final while a suspension has a time limit, and decide whether or not. So if the team could just look at that and at the next meeting report to us as to re-look at 61. Because 61 now speaks about, and Member Hamilton is correct, it's speaking about revocation, which is supposed to be final. So is it that you met all of 61? It's speaking about revocation, more or less. And what we're saying is, revocation is supposed to be final. So is it that that clause was supposed to be speaking to suspension? If such, it needs to be. No, it's not. Then revocation is final. We shouldn't have this breakdown.
Member Green? Go ahead, Member Green.
Sure, I realize I'm still on mute. Sure, a couple of things. I think one, for these matters, I think we have to rely on guidance from the council. Right? Maybe the scheme that they envisioned was not that revocation would be final. Maybe the scheme that they envisioned is that revocation would only be final depending on the offense. I think the council has to provide us some guidance in relation to what they intended to be the overarching scheme of the legislation in relation to revocation and suspension. That's one. Two, I think, Chair, we have to. All right. Look, I believe if we look back at these clauses 10 times, we're going to find 10 different matters to discuss. There is a further process after we are finished in relation to the matter going to Parliament and being debated. I do find out some of the ground that we've covered already, we're going back over it because, again, you look at it with a fresh pair of eyes on this day and you might see something that never jumped out at you before. The reality is that there's no bill act that will be perfect. So I think, we probably, once we get some direction in relation to the council and the overarching scheme, I think we have to see how we can wrap up this section, because I genuinely believe if we go back over these clauses another 5 times, we're going to have another 5 matters. And I think now is time for us to see how we can move it forward. Thank you, Chair.
Well said, Member Green.
You are quite right, Member Green. The more we look at it, the more we may look at it differently. But this particular area of the legislation is dealing with the process of treating with the complaints. And the process in treating with the investigation and the interrogation of the issues. Now, what I think we need to determine is it speaks to the suspension, taking away the teacher from the process, from the act of teaching whilst the process continues. It also needs to make a determination in the final analysis based on the disciplinary measure, what is being asked, and define the terms revocation in the final analysis. And so we just want to be very clear in terms of the objectives that we are seeking, to differentiate between suspension and what would constitute suspension and the various rules around suspension, and also the final determination if, based on the nature of the act of transgression, if it's going to lead to a revocation. And revocation in my mind is a determination that the person will not continue to teach. So we just need to make the distinction. What I found, is that in certain circumstances we use certain words interchangeably. And because we use them interchangeably, it calls for a misinterpretation of the action. So we just need to be very clear in terms of what we're signaling and what we intend as the objective.
Chair,
hold on, Mrs. Watkins has had her hand up. Wilkins, sorry. Nadine Wilkins. Please go ahead.
Yes, thank you, Chair. Good morning to everyone. I just wanted to point out, Chair, that it cannot be presumed that the interpretation that is to be given to revocation is that it is for the rest of that person's life. That is not to be presumed. The word does not necessarily connote that. And if that is what it is intended, that would need to be expressly stated, that the implication of the revocation of a license is for that. Because in other areas, a revocation means you no longer have a license, but a discretion is there to the deciding body to determine the period of time for which this person is no longer eligible to be licensed. So if you're going to make it 10 years, 15 years, 20 years, 25 years, but it's not to be presumed that it automatically means that it's permanent. Thank you.
Chair. Madam Chair, just so Ms. Wilkins' point, I agree with her, but for myself as one of the members of the committee, and I guess through you others would indicate, for me, we should define in the legislation that a revocation means that's it, kaput, finished. The licenses, that is what I interpreted it as, and she's correct that we shouldn't assume that it's clear. We should define it as such if that's what the committee members would like for revocation to mean.
But first of all, we have to determine if that was the intention.
Chair, two things. Because I listened to Ms. Wilkins just now, and I'm the one who brought up the finality of the revocation. And I brought it up because there was nothing in the document that spoke to the intention. So for me, I assumed that it meant that it is a final act. Now, if that is not the case, I think the legislation needs to speak to what it is that the parameters within which they are operating. Because anybody else who pick up the document may have the same thinking. Secondly, Member Green spoke about us not really detaining ourselves with these kinds of discussions, but I'm personally of the opinion that this is where we should try to ventilate as many of the issues as possible, or to even consider some of these issues before it goes any further, because others may not pick them up. And it would make sense for us to identify issues and leave them as is without having some form of finality.
Go ahead, Ms. Gordon-Jones. Thank you, Member Hamilton.
Thank you, Chair. Just to indicate, I think the current reading of 61.1 indicates that the revocation is not final, as in can never return. I think the issue with the reading is the not exceeding 2 years. So I'm not sure if we remove those words, it will assist in indicating that it's not a final thing, that you cannot re-enter the profession based on the intent of the council.
But Madam Chair, I think we're beyond that, in the sense of we're now deliberating whether or not we want revocation to mean never to come back. No, that's what us as a committee, that's what we are contemplating, whether or not we want revocation. So if Dr. Gordon or anyone else from the technical team wants to tell us why it should not, I think why it should not be. Sorry? Right, it depends. I mean, it could be a situation, Madam Chair, where it depends on the offense, that you have revocation being final, or not final. But I'm saying, which is why I started by suggesting a few moments ago, that the technical team, based on the deliberations we're having, could give us some suggestions, bearing in mind we were interpreting revocation as being a final. So if the team could just look back at it and give us some suggestions for us to make a decision on.
Member Green. Member Green, do you still have your hand up?
Oh, Chair, sorry, that was from the last time. Apologies.
All right, thanks. All right, so where we're leaving this is we're asking the technical team to take a look at revocation again, to help to inform us as to why it can or cannot be permanent.
Honorable Chair, I think if we remove the 2 years, this would be a response to if we remove revocation not exceeding 2 years, because I have to go read the Constitution again, but I don't think you can punish anybody in Jamaica forever. Revocation is a punishment, and it's a serious punishment.
Well,
So
that is why we're
depend on
asking for the team to do the research and guide us based on what we are suggesting would be the preferred way. So if you can just do the research to make yourself comfortable and give us some suggestion based on what we're thinking. Because just removing the 2 years does not answer the question and respond to what Ms. Wilkins said. We have to decide and then define in the legislation what revocation means.
Chair, I would love for the Attorney General's chambers to give us some feedback in relation to this, because I still have a concern, a serious concern. I'm not against us putting parameters in place to allow for somebody to come back from a revocation. But for me, the revocation comes into play after somebody has been convicted of a crime with punishment over 2 years. And so that person will always be a convicted individual. So unless we have a situation where somebody goes to an appeal and that conviction is overturned, then I can understand. But I do think that we need to look into this some more. So I would love the SG's input at some point.
SG, are you?
Okay. Yes, but wouldn't the person actually be disqualified? I think persons who are, is not a disqualifying factor to be able to be a teacher. So if the person has been convicted of one of those disqualifying offenses, they can't reapply.
But based on what is being said here, they're saying that you can come back from a revocation.
Not if you're not qualified. Remember that there is another part of the law that talks about being qualified to register.
Agreed.
Right. It can't override that.
So how do we come back from a revocation then? Because Mrs. Gordon...
But if you're disqualified, so I think it's two separate issues. So it depends on the reason your license was revoked. If it was revoked because you were convicted of a certain type of offense, it means you will never be able to be qualified to be a teacher again. But I think there could be some discussion. So in some laws, for instance, you have what's called a cooling off period, where say your license is revoked for something that does not disqualify you in and of itself from applying to be a registered teacher. In some legislation, you will have the cooling off period where perhaps, like, let's say after 5 years or 10 years, you are allowed to then reapply. So you have different forms. A lot of that is really dependent on the policy. But to me, it's a different issue if you're revoked and the reason for the revocation means you are no longer qualified to apply, then that aspect of the legislation will kick in because that overrides everything else.
Right, and we went through describing what are these disqualifying offenses. Right, there's a list of those disqualifying offenses.
So I do get it, Chair, but I'm saying in this situation, I think we need to include a little bit more in this clause, just to make it clear. Because I do agree with the SG that there may be instances where a revocation would not normally be tied to a disqualifying offense. But in a situation like that, it has to be clear in the document.
Madam Chair, through you to Member Hamilton, which is why I'm suggesting at this point we pause the discussion on this section and the team goes back to the drawing board, right? Mrs. Gordon-Jones and Mrs. Douglas-Sherlon goes back to the drawing board, given all that we have discussed and where the minds of the members of this committee are, and then something comes back to us within that context. And I think what was just said, is it by Ms. Aldred, is really important for us to also take into consideration.
Chair, this is a critical aspect of the deliberation. And whilst we agree to go back, and I listen to Ms. Wilkins and the Solicitor General, and it gives the understanding that you may have a revocation that disqualifies you for life, or there may be the consideration of some sort of a cooling off period depending on the nature of the offense. What I want the technical team to do to satisfy my mind in the first instance is, what was the intended objective? When you drafted this and presented to us as a committee, what was your intended objective? And also to take on what we would have presented now for consideration, because it would help me to think what you were proposing in the first instance.
Member Gale, remember that we have a list of disqualifying offenses.
No,
Yes,
Chair.
we do.
One second, Chair. There's a distinction between the disqualifying offense, because you will have disqualifying offenses that leads to revocation, but you may have situation outside of the action itself that leads to a revocation also.
Yeah, but my thing is now, if it is that we have some serious offenses listed on the... What's on the 58? Let me this 1 minute. It speaks to the disciplinary action at 58E, that speaks to revocation. All right, so it says, upon inquiry conducted, depending on the nature of or seriousness of the complaint. What is it impossible for us to review that section that includes revocation and just maintain a suspension? Because if the complaint is not that serious and you decide to revoke somebody's registration, on what basis would that revocation be necessary?
But then
why not just suspend that person for a period of time?
So why do
rather than revoke?
Back to the definition of revocation, and Madam Chair, I think we should just pause the discussion. They take what we have said so far and come back to us, because it comes back to whether or not we're going to define revocation as being final, or whether we're going to define it as final in some instances, and or can be, hold on, or as suggested a while ago, that it can be there's a revocation, but you can come back on a cooling period. You know, I'm not for that, but I want to hear. So if they can just do the research, put something together for us, including it, what was the thinking? Because we were thinking one thing and you intended something else from what I'm seeing on Dr. Gordon's face, because her face tells a lot. Just give us that information so that we can make the decision, because right now we are in so many different places.
Please consider that cooling off period that was referenced. It can be just as effective with a suspension. So you can suspend a person and provide that same cooling off period that we discussed in the revocation.
So guys, remember, look at the different words. Look at the different words that we have. Suspend, revoke. What's the other one? There are three we have, right? Suspend.
The other one was revoke. You can come back with a cooling off period, but a suspension handles that. Yeah.
Warning, censor, impose conditions, suspend, and revoke. If we get to revoke, it's bad stuff.
Exactly, but Madam Chair, the way it's drafted now, that section does not treat revocation as such. So that's what we're saying. They have to revise, because we agree with those phases. But for us, revocation, you should not be able to come back from it. But the section as drafted is allowing you to come back. So that is why they need to go back to the table and re-look at that section within the context of this discussion. We should just pause and allow for that to happen.
So based on the different levels, we're saying that if you get to revoke, if you get to revocation, something serious has happened, such as something very serious has happened, and there should be.
And Madam, we should state, as suggested, that clearly we mean revocation to mean final. There's no coming back from it.
Does that mean, member, that we have to define revocation? No.
We just have to state what the legislation means by revocation, yes.
Define it.
Yes. Yes, we need to define revocation so that it shows. And the reason I'm hesitant to say define it is because it's not so much a definition as it is indicating that it's final. So if that's what the legal persons describe as definition, then yes, a definition.
All right. So members, we're asking our technical team in light
Sorry,
of the
excuse
discussion.
Me, Chair?
Yes, SG, go ahead.
Right. So if the decision is that once a person's license is revoked, they can never, ever apply again for registration. So we put it there as a disqualifying factor. You don't define it. What you do is just put it as a disqualifying factor that they can't apply for a license or to be registered.
So you'd put it in 61.1.
60. It may not be the effect. I'd have to look back. And I think I can ask Mrs. Douglas Sherland to also look back to see where we allow persons to apply for a license and you have persons who are not qualified to apply or right. And I think that's where you would put it because at some point they would have to apply again and then you have eligibility requirements, for instance.
Okay.
So agree with you ineligible.
I leave that to your legal expertise.
I agree, SG.
All right, so we will put double asterisks by this one. All right, technical team. We move on to clause 62.
Madam Chair, I think based on the discussion that we just had, 62C should not be there any at all. Yes, 62C should not be there any at all. 62C. The one that you have put in? It should not be there any at all. There is no... And Madam Chair, which is why probably we really just need to give them time to do 61 and 62, because I think these sections were drafted within the context of revocation. No, you're okay? Okay.
62 is quite different.
Chair, this 62 is in relation to conviction and it is overturned or quashed. So in that case, then the person would need to be paid. That language SG recommended, as in the public service regulations.
Remember,
that would have to be.
SG would have advanced an argument around not using the term reimbursed, because reimbursed give the impression, you spend the money already and you get it back.
Oh, I was concerned. It says for the period of revocation, and we have said revocation is final. So that's what I'm saying.
The language would have to change.
That's what I'm saying. We should allow time for 61 and 62.
It's not revocation in this case.
Exactly, which is why I'm saying we should allow time for 61 and 62 to be reviewed within the context of the discussion, because, for example, C should not be there.
No, this 62.
And also 62B speaks to revocation. So I'm just saying, just give you a clean slate to look at it. No?
No, okay. 62 is in relation to a revocation under 59(2), where the person is convicted.
It doesn't matter where it's coming from. Revocation is final.
No, but if the person if the person's license was revoked because the person was convicted, and then that person went to appeal that conviction and is successful, then the person would have to be reinstated, and then whatever money.
So we revoke before. This leads me to another question, because I now understand what you're saying. Do we revoke before an appeal?
You have to get a decision, and then there could or could not be an appeal.
Are there not instances where you suspend awaiting the decision of an appeal?
Here what happens in this case. A decision would have been taken to revoke internally. And the person externally through the courts, based on the disqualifying offense, would have made an appeal. And the appeal, they would have been successful in the appeal. That's how I read it. And because of the success of the appeal now, the consideration would have to be given that the person can in fact teach. And so this is why they might be talking about in C for the payments to be made.
And this is where I have a little problem, Madam Chair, because let us say, for example, a teacher abuses a child. And when they go to court, on a technicality, they get off the case. And when they get off the case, on a technicality, they still abuse the child. No, they did do it. The act which has a damage to the child has still happened. And which is why I'm saying when we use the word revocation, it should mean revocation. And so I would like to be guided in a legal way as to how, when we revoke, it stays as revoked. Because someone gets off in a court of law on a technical matter does not mean we're talking about the lives of children. And we have to think it through within that context. So I'm not sure if a judgment, what I'm saying is, and I could be wrong, that a judgment in a court should not be enough in certain instances to revoke, to overturn a revocation. For me, protecting a child means more than that. And I would just love us to think about it a little bit. Just take the time and think about it to make sure we're protecting the children.
All right, then members, we will ask for consideration of the technical team for clause, 61 and 62. Ms. Wilkins?
I'd take my hand down because you said the technical team would go on and consider, because I just wanted to point out that some offenses can be expunged from your criminal record. And there's a reliance in the bill on the information in a person's criminal record to determine that person's eligibility and acceptance into the teaching profession. But if we are going to consider it outside of the meeting, then we can look at it as well. So we need not detain the meeting on this anymore.
Chair, just to add that in the consideration, I'm almost sure that Senator Braham made a point here some time ago in relation to this very thing. So in the deliberations, maybe, those points could be taken into account.
All right, I believe we can move on to clause 63. 63, because we're going to be looking, ask the team to look at 61 and 62. So clause 63.
(63)(1) A person who employs a licensed teacher or an instructor shall immediately notify the council if A, the person takes any action, including the dismissal of the licensed teacher or instructor on the grounds specified in Section 50, or B, the licensed teacher or instructor resigns or otherwise stops working for the person in circumstances in which the person, but for that fact, would have or might have dismissed the licensed teacher or instructor on the grounds specified in Section 50. 2, a notice to the council under subsection 1 shall explain the circumstances which caused the person to take action against or dismiss or to conclude that they would have or might have dismissed the licensed teacher or instructor. 3. The employer of a person who is a licensed teacher or an instructor under subsection 1 shall provide the council with any information the council may reasonably require to conduct an inquiry. 4. The employer of a person who is a licensed teacher or an instructor under subsection 1 shall forthwith notify the council if the employer becomes aware that the licensed teacher or instructor has been charged with or committed for trial for a disqualifying offense or convicted of a disqualifying offense.
The caption speaks to employers' duty to report dismissal or resignation of licensed teacher or instructor. But why resignation in this case? Why is there the need for a duty in relation to reporting resignation? If a person resigns, the person would have taken a voluntary action on their own.
Unless
the option of resignation substitutes an intention for dismissal.
Right.
But I'm just asking, in this context, why would there be the need under the voluntary resignation? I want to move away from teaching from Washfoot Gully. And I'm coming to Kingston. So I resigned from Washfoot Gully. Why would there be the need to say that, to report that the teacher would have resigned?
Remember, it is tied to section 50 of the Act, and section clause 50, it has specific items. They have failed to comply with a condition, they have contravened professional standard, they're not a fit and proper person, they have failed to comply with a provision of the Act, or they are convicted or charged with a disqualifying offense. So it is tied to that section. So I guess it's because of the importance of those provisions you would want to notify.
So it is in relation to offenses and not a voluntary resignation. Yeah.
Member, are you satisfied? Should I proceed? It says, but for that fact would have or might have dismissed the person. (64) Enforcement of decision.
No, 1 second. 1 second. I put my hand up because I think the point being made by Member Gale is valid. Nowhere in this provision have we dealt with resignation. The word doesn't appear. I think that's the point he's making. The provision does not deal with resignation at all. So I think that needs to be appreciated before we move on.
Saying is that resignation does not appear anywhere in the legislation.
Not in this clause.
Not in the clause?
nor in 50. My apologies, that's not entirely correct. 63.1b does say the licensed teacher or instructor resigns or otherwise stops working for the person. I apologize. That's not correct. What I said wasn't correct.
Thank you, Ms. Wilkins. 64, enforcement of decision of professional practice and conduct committee. 64.1, the registrar shall take all actions necessary to give effect to a decision of the professional practice and the conduct committee under this part. 2, actions by the registrar under subsection 1 include A, requiring the return of a license or authorization to teach. That's square bracketed, no? B, the amendment or endorsement of a license or authorization to teach. And C, the recording of matters in the appropriate register or in the roll of instructors. So, Chair, based on the previous
we need
discussion...
to specify that it's a registrar of the council, or that's getting too specific?
Chair was asking whether or not it has to specify registrar. Could it say council?
Registrar is this...
Mentioned as having this administrative function. Okay.
But shouldn't it go to the council first? Should the committee go straight to the registrar?
That's why I was wondering if it could say the council shall take all necessary actions. But I'm guided. It could say the council, because the council could instruct the registrar.
Which is what we have in 61. It's a council instructing the registrar in 61.
Right, agreed. But also, are we removing A, 2A? 64 2A, are we removing that clause? Based on the discussion we had earlier.
We're removing 2A, yeah, 2A, we're removing that, yeah. All right, members. Feels like a break. All right.
The Chair?
Yes.
In terms of the rewording for 64.1, we will provide it at the next sitting.
All right, so we have clause 61 and 62 to look at and come back. And 64, 61, 62, and 64. And then we also have, looks like Schedule 1, and 2, is that it? All right. Is there Ms. Spence on from LRD? Are there any? I understand there are some corrections you wanted to be read into the minutes. No Ms. Spence this week? All right, members, I'd love to recommit the minutes. There's one correction. All right, just recommitting the minutes on page 4, paragraph 2. There was a, right, if you start with the second sentence, she noted that in judicial review proceedings, where persons sought clarification to appeal or should be struck out. And it should just go to where persons sought clarification to suggest the review of a decision and so on. Do we accept this recommittal? All right, great. So again, for the next meeting, which will be held on May 25th at 10 a.m., we will hear from our technical team on clauses 61, 62, and 64. And hopefully at that time as well, we'll be able to move into Schedule 1. And, well, this Schedule 1, and then this just says Part B. Is this also of the schedule, Part B of the schedule? And then we have the second schedule. So first schedule, Part A and B, and then the second schedule, Teaching Support Services. Thank you, members. See you at the next meeting.
It's Thursday, May 4. In the headlines, Jamaica celebrates Workers' Week. Justice Minister urging the use of restorative justice program. In business news, gas and diesel prices down for a third consecutive week. Regionally, Barbados and other CARICOM countries are receiving much needed assistance from Japan to assist in Sargassum fight. Internationally, Syrian refugees face tougher restrictions. And in sports, Rothman Powell traded to Barbados Royals. This is the news on PBC Jamaica. I'm Simone Absalom Gay.